This class is about the process of litigation, but a few important aspects of litigation are really about how to end or avoid litigation, and that's what we're talking about in this class session. So let's focus first on settlement. Settlement is an off-ramp from litigation. It can happen at any time. That means that people settle sometimes before a lawsuit is filed because somebody says, I'm thinking of suing you. And the potential defendant says, rather than sue me, why don't you accept this settlement offer? That can happen. It can happen the other way around, too. Tolan v. Cotton settled while the jury was deliberating, I believe. So anytime that the parties want to end the lawsuit through settlement, they are allowed to do that. Settlement is basically a risk management method for the parties. Nobody really knows how a case is going to end until it ends, and nobody knows how they're going to come out. So being able to decide it between the parties themselves alleviates some of that risk, but of course it also lowers the potential rewards that a person is going to get, either a plaintiff in terms of how much they stand to get from the case, or defendant in terms of how little they stand to pay. Settlement also has important implications for attorneys and sometimes somewhat perverse incentives that really highlight the importance of keeping in mind your obligation to your client and your client's best interest. So just to give you an example, if you're working on a contingency fee that says you get, say, a third of any judgment, including a settlement judgment, and defendant offers to settle early on in the case, it may be really in your interest to prod your client to take that settlement offer because you haven't really done a lot of work on the case yet, and yet you still stand to gain that reward. Alternatively, somebody who's getting paid by the hour or is in-house counsel may have less riding on an early settlement because they know that they will keep getting paid regardless. And in fact, sometimes there might be a perverse incentive to ward off a settlement because you can keep working on the case. So there's a lot of possibilities for conflict of interest here, where the lawyer's interests become not completely aligned with the client's. And it's an area that requires particular care to ensure that you are serving your client's best interest. So how does settlement happen? Basically, it's a negotiation. Only parties can agree to the settlement, so you have to get your parties' consent, your client's consent. But insofar as parties are represented by lawyers, they're often advised by them, and it's typically the lawyers who do the negotiating themselves, taking back offers to the client to see what they think about it. Sometimes people will also get mediators or other third-party helpers in the process, especially if it's particularly contentious or the lawyers have trouble getting along. There can be a third party, a neutral person, who goes between the parties to try to find a place where they can come to an agreement, something that they can overlap on. What are the effects of settlement? Basically, it's whatever the parties decide on, because settlement is really a contract between the parties. It typically will involve a voluntary dismissal with opposing parties' consent under Rule 41, and something in return, obviously, for dismissing. But you don't have to settle the whole case. You don't have to dismiss the whole claim. You can settle on one or more issues while keeping the others live. So, for instance, parties can settle on liability and say, we agree, we stipulate that defendant is liable, but we can't agree on the amount that defendant should pay in damages, and so we will leave that determination to the jury. Or alternatively, in what's called a high-low agreement, the parties can settle on a minimum that defendant will pay and a maximum that plaintiff will demand, and leave it up to the jury to determine liability. One thing that people want to be very careful about when conducting settlement negotiations is making sure that the litigation is not subject to repeat itself. So settlement in itself does not preclude a plaintiff from suing on the same claim another time. Settlement just dismisses the claim. So you want to make sure that you include a stipulation in the settlement in which the plaintiff agrees not to sue again on the same claim. Or alternatively, you can ask the court to dismiss the claim with prejudice, which means that you can't file again on the same claim. So this is kind of a trap for the unwary. Just make sure you're thinking about it so that you don't settle a case, have the defendant pay the plaintiff, and then have the plaintiff file suit again on that same claim, because the claim isn't extinguished until there's some agreement to do that or until the court orders it. Speaking of courts, what role do courts play in settlements? Well, by default, a settlement is just a contract between the parties. So much like we've talked about in most of discovery, the court is really not involved in this, and you can decide what you want to do and never tell the court about it and dismiss your claim without ever getting the court involved. Insofar as the settlement is just a contract, then the failure to abide by that settlement is just a contract dispute, enforceable through contract litigation. That can be a little bit burdensome for the person who is bringing suit to enforce a settlement. And so there's a couple of ways of keeping courts involved if you think that this may be a problem. One way is by asking the court to issue a consent decree or a consent judgment, which is a court judgment, just as you might have if the court actually adjudicated the case, but the court judgment contains the parties' settlement terms. So there, instead of just a contract between private parties, you have a legal pronouncement of what the parties owe one another, which is the thing they've decided they owe one another in the settlement. Another option is to ask the court to retain jurisdiction. So this closes the case or allows the case to end for all practical purposes, but it stays in a sense dormant within the court. So if somebody fails to obey a settlement provision, they don't have to start, the opposing party doesn't have to start a brand new lawsuit to enforce settlement. They're already, in a sense, in court before that judge. And the court still has power over that situation. In public law lawsuits, we sometimes see courts retaining jurisdiction for decades over, say, school systems that are found to be failing to provide a legally required education to children, or police departments that are found to be in violation of civil rights requirements, and so on. So you'll often see consent decrees and courts retaining jurisdiction in situations where you have institutions with long-term obligations that courts want to make sure follow the stipulations that they've agreed to in their settlements.